all set, Jerry?
Yeah.
Okay. Good evening. If I could ask you to take your seats.
Where's that from?
This is a regular meeting of the Princeton Planning Board. It's Thursday, January 23rd, 2020. And the opening statement is as follows. Pursuant to Section 13 of the Open Public Meetings Act, adequate notice of the time and place of this meeting has been given by prominently posting the 2019 agenda resolution of the regularly scheduled meetings of the Princeton Planning Board. Such notice has been placed on the official bulletin board of the Princeton Municipal Complex and is to be maintained throughout the year by transmitting a copy of such schedule to the Princeton Packet, Town Topics, The Times, Trentonian, and Comcast Media. A copy has been filed with the Clerk of Princeton on the 8th day of December 2019. Legal notice on the adoption of said resolution appeared in the December 20th, 2019 edition of the Princeton Packet. Would you call the roll, please?
Ms. Capizzoli? Mr. Cohen? Here. Mr. Oakman?
Here.
Mr. McGowan? Mr. Quinn?
Here.
Ms. Sachs? Mr. Texarney?
Here.
Ms. Wilson?
Here.
Mrs. Gunning?
Here.
Ms. Spalla? Mr. O'Donnell?
Here.
We have a quorum.
Thank you. And as you notice, we have a new planning board member, Owen O'Donnell. Okay, are there any announcements, anyone? I should announce that we're probably going to end this meeting a little early tonight, around 10 o'clock or so, so maybe you can pace your remarks accordingly. Let's start with the findings of fact. This is Nelson Spring, LLC, and it's from November 7th of last year.
I'll move adoption.
Were there any questions, comments, or anything? Anyone?
I would just comment that I reviewed the changes that were sent out by email this week, and they're consistent with my recollection of what was the discussion at the approval.
Staff is in agreement with that. There was a question about the sign variance and the placement of the address of 45, the numeral 45, which was the street address, but we've resolved that. We're comfortable with this language. The 45 number will be over the central entrance to the residences, and separate from that, the building identification sign, which received a variance, will be on the forward section over the storefront signage, as it's shown in the plans that were approved by the board. So we're comfortable with that.
Okay.
And Michael, as you address that, that doesn't necessitate any changes to the resolution that Eileen circulated, correct?
That is correct.
Okay, thank you.
Okay, so you want to state your
I
approval?
move the acceptance or adoption of the resolution as amended.
Thank you. Is there a second for that?
I'll second.
Okay, let's take Tim on that one. All those in favor?
Aye.
Opposed? All right, carried. Now, this evening's hearing, no surprise, is Landwind Development Corporation. And this, by my calculation, is our 7th meeting on this application. So, bearing that in mind, let's see where we left off and where we're going forward.
Good evening, Madam Chair. Mark Roselli from law firm of Roselli, Griego, Logino, Lazaro on behalf of the applicant. This evening I will be solo. Mr. Letizia had a personal matter unexpectedly, so he won't be able to make it this evening. So that being said, I think where we left off is that we have remaining for cross-examination our planner, Mr. Hughes, and then I think at that point, it would be open up for the public to ask questions of our experts who had testified, to the extent that any public member of the public have any questions who are not represented by counsel. The one exception is our traffic engineer. Unfortunately, he's not here because he's out of the country. If anyone has any questions of the traffic engineer, we certainly will bring him back. And after that, I believe Mr. Afrin would proceed with his witnesses in his case.
Okay.
Before we get going, there's a couple of house cleaning matters that I'd like to address. During the course of Mr. Brash's testimony, if you recall, it's the first time anyone's ever accused me of not being loud. I'll have to tell my wife that. He referenced a forest management plan that was prepared, and he referred to for Landwin back in 2012. And that particular plan, we had indicated to Mr. Afrin that we would provide a copy for him, and also the complete director would like to enter as our next exhibit, which would be Exhibit A15, and it's a forest steward management plan for Landwin development encompassing the subject property, dated August 12th, 2012 is the stewardship plan. The initial date that the plan was prepared was December 1987, and it was updated in February of 2004. Mr. Afrin's here? No. Without objection, I'd like to offer that exhibit. Yep. Have additional copies, yep. Additionally, during the course of Mr. Brown's testimony, I think Mr. Afrin had asked Mr. Brown regarding whether he was aware or not if the applicant had submitted any type of application to the township relative to the lot to be offered for affordable housing. And at the time, I think Mr. Brown had testified he had not, which he would not have knowledge about. And in fact, so the board's and the record's clear, the applicant back in September did submit a letter to the council, the mayor and council, advising that they made a conditional offer to dedicate block 1001, lots 1, 2, and 14 for use as part of the application for affordable housing. I believe there were some general discussions during the course of the hearing about that. And I'd also like to offer the letter that was submitted to the council dated September 26, 2019 as our Exhibit 16. I have additional copies. Unfortunately, my additional copies I left in my office. See if you need additional copies. I was going to give a copy of these. Okay. 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 Right, there's two attachments. Okay. Some additional.
why don't we take a little bit of public testimony? Mr. Afrin is going to be slightly delayed, so why don't we open the meeting to the public and see if there are any questions about the testimony so far? Okay?
That's fine,
Right.
Madam Chairwoman.
If you'd like to come forward to the microphone and speak, anyone? It's hard to believe that none of you have any questions. All right.
Mark, for Exhibit A16, did you say you only have one copy or you don't have any copies?
I had one copy.
Okay.
There's one copy, and actually, Ms. Name's going to get additional copies.
Oh, okay, thank you.
Sorry about that. I took the wrong group of letters.
All right. Board members, were there questions that you wanted to? Anyone? Go ahead.
Yes, I did have questions I thought I would probably pose later on, but just related to, is the applicant's engineer here that did the stormwater management plan?
Yes.
I had a couple of questions. I listened to the meeting where the engineer went through the 9 non-structural strategies and explained which had been incorporated into the stormwater management plan and which had not. And I wasn't able to hear or understand the information about those that were not included or incorporated, the non-structural stormwater management strategies. So I'm wondering if he could identify those again and explain why they were not incorporated. If memory serves, they were non-structural strategies number 7 and number 8. 7 being relating to low maintenance landscaping and minimizing the use of lawns, fertilizers, and pesticides, and number 8 referring to vegetated open channel conveyance systems. Now, I know that Mr. Afrin just arrived, so if we want to get back into the main lane, we can do that, but I would like for that issue to be addressed at some point, even if it isn't this evening, if we're in a groove, right up until 10 o'clock. Thank you, Madam Chair.
Okay.
That's fine. I just for the record, Mr. Mueller, I guess there's a new board member. I'm not sure if he sat through. If you just want to, for the record, confirm if he's going to participate, read transcripts, the certification.
I have not yet read the transcripts. I just received them this evening, but I will be going through that, and I assume I will not be voting on any issues tonight. Right.
Thank you.
All right. Let me close the public portion of the meeting then, and let's go back to Mr. Afrin, if you're ready.
Bruce, just for your information, and this announcement was made before you arrived, we will be ending the meeting at about 10.
Thank you very much. I wanted to apologize for being late. I knew there was another matter on, and I was delayed a few minutes. I'm sorry about that. So we were continuing with our cross-examination, and I believe we were up to the applicant's planner. That would be Mr. Hughes, I believe. I understand now there's a full copy of the Forest Stewardship Plan, which I was just given by applicant's counsel. I know that was referred to at the last meeting, so I understand that's now an exhibit for the applicant. So is Mr. Hughes available? Is it? Yes. Mr. Hughes. Thank you. Thank you.
For the record, Keenan Hughes, H-E-G-H-E-S.
Just for the record, Ms. Hughes, you were sworn when you gave your initial testimony and you remain under oath.
Understood.
Good evening, Mr. Hughes. I'm going to be asking you some questions on cross-examination. You are the planner retained by the applicant for this project, is that correct?
That's correct.
Now, which plans have you actually designed, if any? Has anything come out of your office by way of actual engineering drawings or any drawings of any nature?
No.
Okay. So who has created the actual site plan in this case?
The firms that have their stamp and letterhead on the various site plans that have been submitted.
Okay. So describe your role in this process.
I'm the planner who is retained by the applicant to evaluate this subdivision and site plan application from a planning viewpoint.
Now, you're aware that there's a Mount Laurel issue related to this application?
No.
You're aware that there's affordable housing allegedly being dedicated, or land for affordable housing being dedicated, is that correct?
There's a piece of the property that is being dedicated to the municipality for the purposes of affordable housing.
Now, to your knowledge, has the municipality accepted that property at this point?
Not that I'm aware of, but that's not pertinent or relevant to the subdivision and site plan application.
I just asked you if they've accepted it. In your judgment, can bonuses be earned for affordable housing units solely because you offer a piece of property for affordable housing?
Well, the ordinance is quite clear in terms of the density bonus that's available on this property in connection with the cluster zoning. The dedication of three acres simply has to meet several criteria, which are clearly set forth in the ordinance.
And what are those criteria?
Among them are less than 20% of the property being environmentally constrained, having frontage on a public road, and I think there's one additional criteria which I don't have top of mind, but we could easily pull from the ordinance.
Well, what's that criteria?
The overall track must be at least, well, let me just.
Bruce, are you aware of Exhibit A-16, which was marked before you came in?
I'm aware, I don't have it.
Oh,
So-
okay. That was just marked. It's now in evidence. Mark, do you want to explain what?
Yeah, I had indicated to Mr. Affron that it was the letter that was proffered by Mr. Letizia to the mayor and council of Princeton, advising them that the applicant was making the subject property, the block is 1001, I forgot the lots, and offering that in connection with this application for affordable housing.
Yeah, I was aware just now generally. I still don't have it yet, but I understand a copy's going to be coming. Thank you.
So per the ordinance, to be eligible for the affordable housing land dedication bonus, the residential cluster must have a tract size of at least 75 acres. At least 70% of the tract must be common open space, of which at least 60% shall be in preserved open space, either dedicated to the municipality or maintained and owned by a homeowners association, and a minimum setback of 100 feet from off-track property lines.
Thank you, Mr. Hughes. Are there any other sections that you regard as predicates in order to qualify for the bonuses?
Yes. I'm just trying to find the specific language in the ordinance. I don't have the specific language at my fingertips. Again, I'm aware that two of the standards relate to public road frontage and the percentage of environmentally constrained portion of the property being under 20%. And then there's a third criteria, which is just not top of mind at the moment.
Okay, so leaving aside that third criteria, aside from that, before you go further, would you just identify for the record the actual ordinance you've been looking at so the record is clear?
I've been looking at Division 9 residential clusters, Section 10B-189, and thereafter.
Thank you. Now, my question before you began speaking of the predicates in the ordinance was different. My question was simply, is it your position that the applicant can have bonus credits simply for offering land for affordable housing?
If it meets the criteria in the ordinance, in terms of the dedication of that land, yes, it's entitled to the density bonus.
Even if the town never accepts the land?
I don't know. I mean, that's really a legal determination, which is outside of the jurisdiction of the planning board. My understanding is if the developer offers up that land for dedication, I imagine any approval will be conditioned on acceptance of that dedication by the governing body.
And what discussions has your client had with the governing body, either in executive session or open session, as to the offering and acceptance of this land?
I haven't been privy to any of those discussions if they've taken place.
Let me just have a moment to look at the exhibit A16 that I now have. Mr. Hughes, are you familiar with Exhibit A16?
Can you share a copy with me?
I can show you the copy your counsel has just given to me. Have you seen this document before?
Yes.
When did you see this document?
I don't recall exactly.
Was it today or on another occasion?
It was before today.
Was it on or about the date of the letter itself, September 26, 2019?
I don't recall.
Have you received any information from your client that the municipality has in fact had discussions with it about accepting the dedication of the land for affordable housing that's referred to in Exhibit A16?
No.
Do you have any knowledge at all as to the municipality's position on accepting that land?
No.
At this stage, in view of the fact that several months have passed since this letter was sent, is there any basis that you're aware of to believe that the town will accept this particular parcel for affordable housing purposes?
I'm just going to object to the form of the questions, ask him for conjecture of this witness, and I don't know he would be able to know what the minds of the township council is or the mayor relative to acceptance.
I simply
pure
asked,
conjecture.
is there any, I asked is there any basis that he is aware of? So I'm asking for his own knowledge.
I'm not aware of the thinking of the members of the municipality's governing body.
Do you have any information at all about the town's position on accepting this land?
I think I just answered your question.
My question is simply very broad. Do you have any information at all about the town's position on accepting this land?
No, until it's formally accepted, I don't have any knowledge of what's in the minds of the governing body.
Well, now you say until it's formally accepted. Is it your testimony that there's some preliminary interest expressed by the town in accepting this land?
I can't speak for the municipality in that regard.
So my question is simply this. At this moment sitting here today, do you have any information as to the town's position on accepting this parcel for affordable housing?
What I know as the planner related to this project is that the applicant is proposing to dedicate 3 acres of this property to the municipality for affordable housing in compliance with the requirements of the ordinance.
And that's all you know?
Yes.
Thank you. Now, are you aware of low-income tax credits with respect to affordable housing projects?
Yes, but it's irrelevant to this particular application.
Well, I'm glad you've declared it's irrelevant before I've put any propositions to you. I simply want to know if you're aware of that subject.
I'm generally aware of low-income housing tax credits.
Have you worked in affordable housing applications, Mount Laurel applications, compliance and fairness applications in the past?
I have some experience in affordable housing.
What is your experience in affordable housing?
As a planner dealing with affordable housing compliance, settlements on behalf of both municipalities and private sector clients.
Have you prepared compliance plan?
Private sector clients.
Have you prepared compliance plans on behalf of municipalities?
My firm is prepared a lot. It's not my principal area of focus.
It's a simple yes or no question. Have you prepared such plans in Mount
Not
Laurel?
personally.
Thank you. Have you prepared fairness evaluations for municipalities?
What do you mean by fairness evaluations?
Do you know what the word fairness means in the context of Mount Laurel litigation?
Yes.
Have you prepared fairness evaluations for municipalities?
No.
Have you done so for private developers?
I've evaluated sites as potential affordable housing eligible properties.
Have you actually prepared compliance plan analyses in fairness hearings as a special master, for example, for a court?
No.
Okay. Now, are you aware that, would you agree, unless you don't have sufficient knowledge, please say so, would you agree that most affordable housing projects are financed with low-income tax credits?
I did not provide any direct testimony on this issue, and it's completely outside the scope of this application. There's a dedication of 3 acres of land to the municipality in accordance with the ordinance. Any other discussions related to affordable housing are just not pertinent to this application.
Well, I'm glad you are making yourself the judge and jury, but I'm putting a question to you, and unless someone on the board orders you not to answer it, you have to answer. Are you aware, or would you agree, that most affordable housing developments in New Jersey are financed with low-income tax credits?
Again, I'm just going to object. I think the witness makes a point, is that obviously this particular issue, this particular line of questioning was not included within his testimony, so it is beyond the scope of his direct.
It's actually what we call a credibility challenge. He has offered an evaluation that says this project is entitled to bonus credits because of the offer of land for affordable housing.
That was not his testimony. The testimony was the fact that the offer was made in compliance with the ordinance, and the ordinance was followed. And I think that was that question was asked and answered. So where you're going is beyond, it has nothing to do with credibility, and he's indicated that he has no knowledge of how the township's going to react, other than the fact that the offer was made in compliance with the ordinance, and then ultimately that decision has to be made by the governing body.
He has made testimony and offered testimony endorsing that this body grants 6 bonus credits because of the proffer of land for affordable housing. He has testified that in his view this qualifies for those bonus credits. Therefore, the subject of bonus credits and the affordable housing component has been introduced by the applicant and in part by this witness. My questions go to the validity and credibility of that proffer for the 6 bonus credits. It is entirely proper, and I'm going to persist.
Again, and I'm going to object, I don't believe it is proper. Ultimately, that is a decision to be made by the governing body, which has been testified to. And again, from a legal perspective, to the extent that the bonuses are dependent upon the township accepting this land, it certainly is within the purview of this board to make that a condition of approval.
Well, I'm going to
Sorry. And I believe that is the sub and substance of what is required under the ordinance, which again, we've met the requirements of the ordinance, and I believe that's what the planner's testimony is. When you start asking about tax credits and whether or not the majority of affordable housing projects are testified with relative tax credits, I don't know that any planner could answer it, but certainly that has nothing to do with the ordinance or his testimony.
Well, actually, planners are precisely the people who are involved in those submissions in fairness hearings and compliance hearings. It is actually part of the licensed professional planner's work in New Jersey. In any event, I'm persisting with the question. Are you aware that most affordable housing developments are financed through low-income tax credits?
And again, I'm going to object and ask that the board direct that he not be required to answer because it's beyond the scope of direct and beyond the scope of what's relevant relative to this particular application.
The board cannot direct a witness not to answer a question that goes to the credibility of a portion of the application. If the board were to accept this invitation, it will lead to an almost certain reversal for interfering with the objector's rights, if it's approved.
Again, and I've laid the foundation, it has nothing to do with the credibility application. The fact is that it meets the land proffered, and that there's been testimony on it, meets the conditions of the ordinance that allows the offer to be made. Ultimately, it's a decision to be made by the governing body. There is nothing in the ordinance that goes beyond those particular requirements, the criteria, to see if the land meets the requirements for affordable housing.
Well, it's quite clear that council's persistence in the objection underscores its relevance.
What is its relevance? Is the legal theory that underscores what you're asking that even if the council accepts the 3-acre parcel, because I think they have to. I mean, that's.
You think the council has to accept the parcel?
Either they're going to do it beforehand if they do it, or it's going to be a condition of approval.
I see. I'm sorry. You meant in terms of this. Yes.
Yeah, but it seems to me where you're going is that unless there's, in addition to that, some kind of demonstration that there's a financing mechanism available for actually financing the construction of the affordable units, that the applicant is not entitled to bonus credits, even if the parcel is accepted. And I think that, I think it's a misreading of the ordinance. And Derek, do you want to jump in on that at all?
I agree with what you're saying so far.
Jerry, the board and the applicant cannot limit an objector's case simply because of your particular opinion that the subject matter is not within the scope of the ordinance. The ordinance actually does not speak to most dimensions of the problem. This board has to use what's known as legal discretion in making judgments. It can't simply take a swamp that has, well, a swamp will work anyway. But the point is the board has to be able to satisfy itself that in granting credits, it has a piece of land that as a practical matter is suited to affordable housing. One can't simply take a piece of land 15 miles from any highway, any bus stop, any shopping center, in an extreme example, and say, oh, well, they're offering that, we'll give it affordable housing credits. The entire underpinning of the ordinance, which is part of the whole Mount Laurel structure in New Jersey, is that realistic affordable housing is encouraged. We give bonuses when the housing project or the affordable housing component is reasonable and realistic. This board has no right to accept this application and grant bonus credits unless it satisfies itself that it is a reasonable proposal. And I have the right, representing objectors, to demonstrate that there are significant flaws in the reasonableness of this component of the plan. And there's no basis to stop my questions.
I think this argument goes to council, not to the planning board. If you don't think,
If you even know what I'm driving at because you haven't allowed me to go further and ask the questions. The point of these questions is to demonstrate that low-income tax credits are not available to finance this affordable housing component because they're not in a town center or in the appropriate zones in the state master plan. Particularly, may I have a moment, please? The ordinance actually says residential clusters which dedicate suitable land for affordable housing. And so the board must make a determination that this is suitable for affordable housing. It has an initial obligation before it approves a plan with bonus credits to satisfy itself that this is suitable for affordable housing. And that invites the credibility challenge as to whether or not this is in fact suitable. If this land is not located in a place where low-income tax credits are available, and if those are a primary mechanism of funding such projects, that relates to whether it's suitable. The board must hear this.
May I ask a question of our planner, of Mr. LaPlace at this time? Mr. LaPlace, you're a licensed planner, obviously. Are you aware of affordable housing that's been bonded for without tax credits by municipalities?
Personally, I am aware of some projects. I don't know what the percentage would be over, considering all of
These
the
are projects in New Jersey that have been fully funded by municipalities.
Oh, yes.
Thank you.
There are some projects that are, but most and many are funded by low-income tax credits. And so the question of whether funding is legally available for this site is relevant. Now, I understand Mr. Quinn's point that it could be funded by a bond potentially, but that does not mean the question of whether low-income tax credits are legally available for this particular site is not relevant. It is relevant, and the board should be fully apprised of all facts. I can't understand why anyone would want to block the questions. Why would we want to give bonus credits to a luxury housing development for affordable housing if, in fact, there are serious legal defects in that parcel being used for that purpose?
So again, I'm going to object because Mr. Afrin is providing testimony, right? It's not argument, it's testimony. And he's putting in facts into the record that are not facts, haven't been established. There's been no testimony by any planner relative to the availability of tax credits, and no one can say sitting here, certainly not Mr. Afrin because he's not a witness, what the availability of tax credits are and whether or not. The only testimony we have from a planner is that there are affordable housing developments that have been built by township without tax credits.
I'm prepared to continue with the questions, and I think this is wasting enormous time.
I agree.
We would have been done with this in about 60 seconds. We would have been done with this in about 60 seconds in total. Actually, Wanda, we've been through those times before, and I always run slightly afoul. But I will be quick. Are you aware that many or most affordable housing projects in New Jersey are financed with low-income tax credits?
Real estate finance is outside of my realm of expertise.
Is the answer you don't have knowledge on that subject?
The answer is real estate finance is outside my area of expertise.
Well, that doesn't mean you aren't aware that affordable housing projects are typically funded with low-income tax credits. Just
Again,
answer that question.
I'm going to object to the form of the question because it infers a conclusion that has not been established. That being that the majority or most affordable housing projects are financed by tax credits. Nowhere in a record, there's been no evidence presented to this board, so the form of the question is totally inappropriate.
I'm asking the witness what his state of knowledge is on the subject. All he has to do is say, I don't know.
And that question's been asked and answered at least 3 times.
No, actually, the witness has a habit of answering questions that are not actually asked. My question is very simple.
Bruce,
Do you have...
why don't you change for that to whether, and then I think the form of the question would be proper.
Fair enough. It's the same question. Do you have knowledge as to whether or not low-income tax credits are frequently used to finance affordable housing projects in New Jersey?
I'm aware that some affordable housing projects are subsidized.
Are you aware that they are subsidized through low-income tax credits?
I'm not aware of the particulars.
Are you aware, just one moment, please. Are you aware of the Council on Affordable Housing second round rules, which are still in force in New Jersey through the court process, that require that affordable housing sites to be eligible for low-income tax credit funding must be located in planning areas 4 or 5 or be in a state-designated center?
I'm not intimately familiar with every provision of the second round rules. What I know is the applicant is dedicating 3 acres of this property to the municipality for the purposes of affordable housing. And that's all we need to demonstrate at the planning board in the context of this site plan and subdivision application.
Well, I didn't ask if you were intimately familiar with all COA rules. I asked if you're familiar with these particular rules. Are you?
Yes.
And you agree that in order to qualify for low-income tax credits, the project must be situated in planning areas 4 or 5 or in a designated town center?
I'm not in a position to render an opinion on that.
Do you agree that that's what the rules say?
I don't have the rules in front of me. It's been some time that I looked at those, so you may be right, you may be wrong. I can't confirm.
Would you agree that this site is not in areas 4 or 5 or in a designated center?
I have not looked at the latest state plan designation for that portion of the property.
Excuse me, I've read it backwards. They must be in areas 4 or 5 to qualify. Are you aware that if it is in area 1 or 2, planning area 1 or 2, it will not qualify for low-income tax credits?
No, I'm not familiar with that.
Okay. Would you agree that this site is not in areas 1 or 2?
Again, I just testified that I'm not familiar with the latest state plan designation for this portion of the property.
Okay. And would you agree that this site is not in a designated center?
Same answer.
Okay, thank you. Have you evaluated the distance of this affordable housing site from the nearest public school?
No.
Have you evaluated the distance to the nearest grocery store or supermarket?
No.
To the nearest park or playing field?
No.
To the nearest library, public library?
No, and the reason is because it's not required and it's not pertinent to meeting the requirements of the cluster ordinance.
Is there a bus stop at the site or near the site of this affordable housing project?
It's not something I evaluated.
Do you know where the nearest bus stop is?
I don't recall.
Did you ever know?
What was that question?
Did you ever know where the nearest bus stop was?
I don't recall.
Okay. What evaluation have you or your client conducted as to the safety of pedestrian circulation with respect to this affordable housing site?
Well, we've put in a pretty extensive direct presentation in support of our site plan and subdivision application. If it wasn't touched on by one of the other witnesses, it's because it wasn't relevant to supporting the application.
Have you done an analysis of pedestrian safety circulation? In
You're asking if
relation
this, I'm sorry, bro. You're asking if this witness.
Well, I'll do it both ways. I'd ask whether he or his client. I'll do it both ways. Have you or your client conducted an evaluation of pedestrian safety circulation in relation to the site?
I don't know if my client has.
Have you?
It's outside of my area of expertise.
Based on the current absence of mass transit stops at or near the site, would you agree that any resident of affordable housing at this location would be entirely dependent on personal vehicles for transportation?
That's an aspect I have not evaluated in connection with this application.
As part of your work on this application, did you conduct any evaluation or analysis of the Princeton Police Department's record of motor vehicle accidents for Herrontown Road?
No.
Did you conduct any evaluation of the records for pedestrian or bicycle accidents on Herrontown?
No.
Have you read the Princeton Master Plan in connection with this site?
Yes.
Would you agree that the Princeton Master Plan says this site is to be set aside for preservation?
Actually, what the Princeton Master Plan says, and this is on page 93 of the 1996 Master Plan, the open space and recreation element, it specifically references this property, and it says any new development on the property, clustering should be recommended in order to obtain a conservation easement over the environmentally sensitive portions on the site, which is exactly what is proposed as part of this application. In addition, the conservation element of the 1996 Community Master Plan on page 123 similarly identifies this property and indicates this area off Mount Lucas Road is of critical importance due to stream corridors, wetlands, woodlands, and steep slopes. A conservation easement should be sought for the environmentally sensitive portions of the site. Again, with the conservation of 67 acres of the site, that would also be accomplished in connection with this application.
Are you saying the master plan does not recommend this site for preservation?
The master plan clearly recommends this site for clustering of development within the most appropriate portion of the property.
Does the master plan recommend this site for preservation?
It recommends it clearly for clustering.
I'm asking you a specific question. Does the master plan recommend this site for preservation?
And
Yes
my
or no?
answer is it recommends a portion of the site to be preserved as part of a residential cluster development.
That's your answer at this point.
That's my answer.
Okay, thank you. Where in the Princeton master plan, I'll strike that. Are you familiar with the New Jersey State Development and Redevelopment Plan?
Yes.
Are you familiar with the plan's framework of planning areas?
Yes.
And can you tell the board how the Landwin property is mapped under the State Development and Redevelopment Resource Planning and Management Structure?
And I think what I said earlier I would provide the same answer here, which is that the State Development and Redevelopment Plan is not something I focused on or evaluated in connection with this application because it's not relevant to meeting the criteria of the ordinance.
Well, regardless of your view as to whether it's relevant, my question is very simple. Can you tell the board how the Landwin property is mapped under the State Development and Redevelopment Resource Planning and Management Structure?
And I think I've just answered that question 3 different times, which is to say that I have not evaluated the State Development and Redevelopment Plan in connection with this application.
So your answer is no, you can't indicate that.
I answered the question.
Is your answer no? That you cannot indicate how
No,
it is
because
mapped?
I didn't evaluate it.
Are you familiar with that element of the State Redevelopment Plan? Development and Redevelopment Plan?
When you say element, what are you referring to?
The structural mapping for the Landwin site.
I just answered the question by saying I did not review any mapping of this particular property because it's not relevant to the site plan and subdivision application.
So is your answer that you are not familiar with that section of the plan?
Section of what plan?
The section of the State Redevelopment Resource Planning and Management Structure concerning the mapping of this site.
When you say the mapping of this site, what are you referring to?
Can you answer the question as put to you?
I think I've answered it maybe 6 times now, which is that I have not evaluated the State Development and Redevelopment Plan in connection with this application because it's not at all relevant to what we're trying to do here, which is to demonstrate compliance with the ordinance.
Now, my question was not, did you evaluate the state plan for this purpose? My question is simply, can you tell the board how the Landwin property is mapped under the State Development and Redevelopment Resource Planning and Management Structure? I'm not asking whether you've evaluated it. I'm asking, can you tell the board how it is mapped?
And I believe that the applicant provided the answer to the question. It may not be the answer that Mr. Affron wants, but he provided an answer to that on multiple occasions.
The applicant simply said, I've not evaluated the state plan. I'm simply asking if he knows how it is mapped on the state plan.
Just to cut through this, it does call for a yes or no answer. So if you could just say yes or no.
The answer is no, because it's not relevant to this site plan application.
How do you know something's not relevant if you don't bother to look at the state plan?
Well, that's my opinion from a planning perspective based on meeting the criteria of the ordinance.
Is that your complete answer to my question?
Yes.
Thank you. Doesn't the 2017 Princeton Master Plan reexamination at page 17 actually state, quote, Princeton Community's planning efforts are consistent with the State Development and Redevelopment Plan, close quote. And if so, wouldn't that mean it is relevant for you to consult the state plan?
No.
It doesn't say it, or it's not relevant?
Can you repeat the question?
I think it was very clear, frankly.
Well, I'd like you to repeat it.
Are you aware that the 2017 Princeton Master Plan Reexamination Report states, quote, Princeton Community's planning efforts are consistent with the State Development and Redevelopment Plan, close quote?
Yes.
Doesn't that mean that a planner evaluating a site plan application in this community ought to at least look at the State Development and Redevelopment Plan?
No.
Thank you. Would you agree that the 2017 reexamination report states that the entire Princeton Ridge requires, quote, preservation and protection, close quote.
Yes.
And you would agree that the Landwin site is within the Princeton Ridge?
Yes.
Thank you. Are you aware that on the 2011 Princeton Open Space and Recreation element of the master plan, that the entire Landwin tract is shown as, quote, proposed open space, close quote?
Yes.
Wouldn't you agree that by showing the entire property, the entire Landwin tract as proposed open space, that the planning board was recommending that the entire property should be preserved?
No.
Are you familiar with the Princeton Natural Resource Inventory?
Yes.
And would you agree that the Princeton Natural Resource Inventory states that, quote, almost all of Princeton's critical and suitable habitat is located in the northern tier of the former township along the Princeton Ridge, close quote?
I don't recall that specific language in that document, but if it exists,
You would agree
I
that
would not be surprised.
You would agree the Landwin tract is in that northern tier?
Yes.
Wouldn't you agree, therefore, that the Natural Resource Inventory recognizes this entire tract as comprising an important part of the remaining critical habitat in Princeton?
Well, I would say that's why both the master plan and ultimately the ordinance implemented, both first recommended and then implemented this cluster provision. And in fact, in 2017, when Princeton amended the ordinance, specifically the cluster ordinance, it made specific reference to this property. It says, and this is ordinance number 2017-46, it says, whereas the Princeton Community Master Plan open space element specifically recommends that new development on the 90-acre Landwin tract off Mount Lucas Road and Herringtown Road be clustered in order to obtain a conservation easement over the environmentally sensitive portions of the site. So this is the governing body referencing the master plan and identifying a specific property, which it's saying, we want to use this cluster provision in our ordinance to maximize the preservation of a privately owned development parcel.
What year is that resolution?
2017.
Again, to clarify the record, it's an ordinance that was adopted by council.
May I see the document? You would agree that under the ordinance, we'll strike that, this resolution you cited was simply a resolution adding some technical corrections to the existing code, isn't that correct?
No, actually, that is an ordinance which amended the existing cluster ordinance to specifically address this property and essentially implement the project that's now before the board for approval.
Well, where in the ordinance do you contend it was authorizing this particular site to be clustered, other than the whereas clause which you read?
May I have the document?
Yes.
Well, I would say first and foremost, the whereas clause is a pretty explicit policy statement from the governing body as to the intent of this ordinance, and it clearly mentions this specific property.
Where else in the ordinance does it refer to clustering on the Landwin tract?
And then elsewhere in the ordinance, the changes that were made, it's pretty clear that a number of these were made in anticipation of this property in particular being developed under the cluster provision of the ordinance.
Where do you derive that from?
Some of the bonus provisions, the notion that 70% of the tract must be common open space, the setback provisions, all of this is geared toward allowing or facilitating the cluster development on this property that's presently before the planning board.
Now, may I have that back for a moment, please? You would agree that in making amendments on this occasion, the council left intact the remainder of the ordinance governing clusters and site plans review?
Yeah, certainly. Look, my interpretation of that ordinance was that the municipality had an existing cluster ordinance in place. The opportunity arose as to a potential cluster development of this particular property, and there were certain amendments that were needed to that ordinance that was implemented through the ordinance that's in your hands, and that was done consistent with the recommendations of the master plan.
Would you agree that they left intact section 10B 189.1D when it defined the findings that the planning board must make in connection with approving any cluster application?
Yes.
And you would agree that that provision states that the cluster must not have, quote, an unreasonably adverse impact upon the area in which it is proposed to be established. It says that, doesn't it?
Yes.
That was never changed, was it?
No.
No one liberalized the standard for the Landwin tract, did they?
No, that's because it can be easily achieved on this track.
In other words, they can easily achieve the standard that there be no unreasonably adverse impact on the surrounding area?
Yes.
That's your testimony?
Yes.
Okay. You also agree they left intact the statement in subsection D, quote, this evaluation shall include reference to the natural resources inventory, close quote.
What was the question?
You also agree that the council left in section 189.1D the provision that states this evaluation shall include reference to the natural resources inventory, close quote.
Yes.
And so this board must consider the natural resources inventory in any decision to approve a cluster. Isn't that correct?
Absolutely.
Okay. I just need a moment, I'm sorry. Would you agree that in the Princeton Master Plan, the entire Princeton Ridge area is also designated as a special environmental area, close quote?
I don't remember that specific designation in the plan.
Could you explain your understanding of the meaning of an as-of-right plan?
I would say from my perspective, it's a variance in waiver-free application.
Thank you. In other words, the site plan, to be an as-of-right plan, must not require waivers or variances from the existing code.
Correct.
Just one moment, I'm sorry. Who developed the as-of-right plan that the applicant submitted in this case?
It was the firm whose stamp and letterhead is on that plan.
Is that your firm?
No,
Did you participate in any way in developing that plan?
no.
Is that the engineers retained by the applicant who developed that plan?
I believe so.
In Princeton, can houses be built on a road that is not dedicated as of right?
Any developable property needs to front on either an existing or mapped public road. Otherwise, it requires what's known as a planning variance.
So in other words, if houses were not fronting on an existing or dedicated road, you couldn't build those houses as of right. Is that fair to say?
As far as I know, every single house in this application fronts on a proposed roadway.
A proposed roadway.
Correct.
But doesn't the right to build the house without a variance require an existing public road?
No.
Can you find a section of the code that allows houses to be built where there's no road?
I mean, that happens all the time in connection with subdivision and site plan applications. Someone proposes cul-de-sac, a new road on which the houses front. I mean, that's customary in planning and development.
Well, that's because in a subdivision, a developer will dedicate the road he wants to build to the town, giving rise to a public road on which the houses can front. Isn't that correct?
In some cases.
Well, for example, you've got a cul-de-sac on the screen here under the cluster plan, and that road will eventually be dedicated to the town if this was built, correct?
I don't know the legal mechanisms by which, who's going to take jurisdiction of that, but the bottom line is those are roadways which the public will have access to. Each lot is located along a road.
Well, going back to your as-of-right plan, could you please put that on the screen?
It's not working. It's not advancing.
Now, you see that there are 3 lots that front to the left. There's a line that says Herrontown Road, and there is a road intersecting the site or bisecting the site. You see that there are 3 lots fronting on what is called Herrontown Road in this as-of-right plan to the left of that bisection. Do you see that?
Yes.
Now, you would agree there's no existing road there, isn't that correct?
It may be unimproved, but it's a proposed mapped roadway.
Well, is it a road that is dedicated as a public roadway in Princeton?
Yeah, it's a mapped road.
You're saying that road is dedicated as a road?
I believe so.
Do you know as a fact?
That's my understanding, and that's my interpretation of the documents. I believe it's shown on,
Well, your interpretation of which document?
I believe it's even shown on the tax maps, that's an existing
Does it
mapped
say
road.
proposed road or a dedicated roadway?
Well, it's a mapped roadway in the municipality.
Now, that roadway is not paved, is it?
It's unimproved.
Right.
portions of
Now,
it.
are you permitted as of right to build houses fronting on an unimproved road in Princeton?
Well, you can improve the road.
That's not what I asked her. That's not what I asked her. Are you permitted as of right to build houses on an unimproved roadway in Princeton?
You would have to improve the roadway.
Well, if you don't own the roadway, someone else would have to agree to do that. Isn't that correct?
Correct.
And your client does not own that proposed roadway.
Oftentimes, in the context of development applications, there are improvements that the developer would make in connection with a given site plan, and some of those might involve off-track improvements, such as improving roadways or other infrastructure in the area.
But those 3 houses front on an unimproved tract, whether it's a dedicated road or not. Is that correct?
I think I've said it maybe 8 times now, that
Well, you've said it maybe
those
twice.
lots are located on a mapped municipal roadway in Princeton.
Well, you don't have anything in front of you that shows that at present that it's actually a highway under the zoning code.
My testimony is that I believe that road is shown, even reflected on the tax maps,
Let's
as a
assume-
public road in Princeton.
Let's assume for the sake of argument that it is, based on what you've said. You agree that the zoning code does not allow a house to be built on an unimproved road. Isn't that correct? It's a yes or no
No,
question.
that's not my understanding.
Are you saying that in Princeton you can, as of right, put a house on an unimproved road?
You improve the road as part of the application.
That shows houses built on what is an unimproved piece of road called Herrontown Road. Isn't that correct?
Well, I can tell you the planning board would not approve an application along a dirt road. I mean, the road would be improved in connection with this theoretical as-of-right plan.
This plan is not one that is before the planning board for ultimate approval. This is what you're saying your client can do right now as of right. Isn't that correct?
Correct.
And right now as of right, you cannot put houses on an unimproved road under the zoning code in Princeton. Isn't that correct?
No.
Thank you. What is the acreage per residential unit in the, I can't really see the map from here, the RA zoning district?
I don't think I understand the question.
In your as-of-right plan, how many minimum acres are required in the zoning district to build a house?
In the RA zone,
Yeah.
4 acres.
Now, look at the top left-hand site. There is a house lot up there. Do you see that? In the very far left-hand corner?
Yes.
That actually is in 2 zones, isn't it?
Yes.
It's in the OR1 and the RA zone, isn't it?
Correct.
So it doesn't have 4 acres in the RA zone, does it?
No.
So in other words, to build that house, you would need a variance to build on less than 4 acres in the RA zone. Isn't that correct?
No, I disagree. The ordinance specifically says that the cluster option is available and permitted within the OR1 zone. So in terms of evaluating a so-called as-of-right or compliant plan under conventional zoning, you take into consideration the entirety of the tract, including both the OR1 and RA and RB portions.
This proposed as-of-right plan is not a cluster plan, is it?
No.
In order to build a cluster plan, you have to have permission from the planning board. Isn't that correct?
I believe there's a requirement that you are to submit a conventional zoning plan to demonstrate what the permitted yield would be under
you
the existing zoning
I
requirements.
think you misunderstood my question. My question is very simple. Can that house in that far left-hand corner be built as of right today on less than 4 acres on the RA zone without a variance?
I think today, under conventional zoning, I don't know how the municipality would interpret the ordinance in
I'm
that
not
regard.
asking how they interpret. I'm asking you as a planner right now, can that house in the far left corner, that far left lot, be built on less than 4 acres in the RA zone without a variance? Yes or no?
And it depends on how the ordinance is interpreted. I mean, some municipalities allow you to utilize the zone requirements for the zone that applies to the majority of the lot, which would be the RA zone in this instance. I'm not sure how the municipality interprets their code in that regard. It's obviously a split zone lot. But for the purposes of this application, this is simply a theoretical exercise to demonstrate, again, under the cluster, which accounts for both OR and RA-RB properties, what would be permitted on the overall tract.
In order to build this theoretical exercise, it has to be allowed under the zoning code today. Isn't that correct?
Right.
Thank you. That's the yes or no question. Thank you. Today in Princeton, can you build a house in the RA zone on less than 4 acres of land without a variance? Yes or no?
This question has been asked and answered several times.
And it's not been answered at all. The witness keeps saying, well, in New Jersey, there are different
He
interpretations.
says he doesn't know what the Princeton practice is and how the ordinance is interpreted.
I didn't
think
ask
that's-
about the Princeton practice,
That's the
Jerry.
answer.
Jerry, excuse me. I didn't ask about the Princeton practice, and I didn't ask about how other people interpret it. He is a licensed professional planner. He has endorsed this as-of-right plan as a plan that can be built right now. His client came here and said, if you don't let us build that cluster plan, we can do that as of right today. Now, I'm asking him as the planner who's endorsed that, can that lot on less than 4 acres of land have a house put on it in the RA zone without a variance in Princeton today?
I answered your question. I mean, the answer is it depends on each municipality's zoning and how they interpret their ordinance. That's my answer.
With respect, Mr. Mueller, I asked simply, in Princeton, under our zoning code, can that be built without a variance? I didn't ask how other towns interpret their zoning code. The witness truly is not answering the question. I'm going to ask it one more time.
I think it's been asked and answered several times now. Please move on.
I don't have to follow your specific direction, Jerry. I'm entitled to an answer to a direct question.
May I
My
ask a
question is very...
question?
Sorry.
Do I interpret your answer to be, since it's based on how the municipality would interpret, that you're unaware of how the municipality would interpret it, and thus you simply don't know?
That's a fair
Is that
summary of
good
my
enough
answer.
for
Well,
you?
actually, I appreciate that, Ms. Wilson, but my question is really very simple. As a planner who's read the zoning code, can you do that today in Princeton without a variance? It's something planners do every day of the week. They have to look at the code and say to their client, do I need to apply for a variance? It doesn't depend on what you think the council would interpret its ordinance as. It's a question that a planner deals with every single day. Looking at the code, can you build that house on less than 4 acres of land without a variance?
I've answered the question.
I'll move on, but the record will show ultimately there's no answer.
Can I ask a clarifying question about that?
Yeah,
It-
that's true.
If you include both of the zones that are on that site, is it more than 4 acres? Is it 4 or more acres?
It certainly would be 4 acres, but the point is you can't do that without a variance. That's the question I'm putting to the planner.
I mean,
You can't
I think the
combine two
I think the
zones.
question is for the planner.
Oh, I'm sorry.
Just because of the way the question was asked, it was confusing to me. If that's, but that site is at least 4 acres, including all of both of the zoning areas, correct?
yes.
Okay, thanks.
Are you aware, Mr. Hughes, that a developer can, on its own, combine zones from 2 zones to make up the minimum in 1 zone without a variance?
I didn't follow the question.
Can a developer decide he's going to take parcels in 2 zones and combine them to make 1 zone to meet the minimum acreage in one of the zones without a variance?
Again, the question is not clear. You're talking about combining zones. Do you mean combining properties in 1 zone? I'm not understanding the question.
The far left lot has less than 4 acres in each of the 2 zones, correct?
Correct.
And the RA zone requires 4 acres to build a house, correct?
Correct.
Can you build that house by using the acreage in the OR part of the property without getting a variance?
So this is the same question that you've posed to me 10 times, just in a different manner.
Well, I'm
and I'll
following
answer
Mr.
it the
Oakland's
same way.
question. Mr. Oakland posed this question. And so in your understanding, can you do that as a developer without getting a variance?
And my answer is it really depends on how the municipality interprets its ordinance. What we know is that based on the review letters from the professionals, they've reviewed this plan, they find it compliant with the ordinance, and that's as far as I can render an opinion on the matter.
Okay, thank you. Would you agree that if you could not build the 3 houses on the unimproved frontage and the lot in the far left corner, that your client would not be entitled to a minimum of 20 units in the cluster?
If you can't build 20 unit, if
let me
we
rephrase.
lose lots, we lose lots.
Right. So if those 3 lots on the unimproved frontage, and if the upper left-hand lot can't be built because they're not as of right, your client would only have a maximum of 16 in the cluster before bonuses. Isn't that correct?
Correct.
Okay. And that would, of course, affect the bonus percentages going forward.
Correct.
Okay, thank you. I just need a moment. I'm checking my last questions. How does your client conclude there's no unreasonably adverse impact if it has made no survey of the number and species and age of the trees to be destroyed on the cluster?
Well, I can't speak for my client. I can only speak for myself.
Well, I'm asking you as the representative of your client on this plan, how is that proposition supported?
Well, this is a roughly 90-acre property, which under conventional zoning would be essentially 100% disturbed, with the exception of the environmental constraints on the site. I mean, it would be substantial disturbance to existing woodland, other sensitive areas of the property, and instead, consistent with the master plan and the ordinance, the applicant is proposing this clustered residential subdivision, which focuses development on the previously disturbed portion of the property, does not impact any environmental constraints on the property, is designed in full conformance with the letter interpretation from the NJDEP, and maximizes the amount of open space that will be preserved and dedicated in perpetuity.
Well, my question was very simple. How can you say there'll be no unreasonable adverse impact if you've made no survey of the trees, species, and numbers, and age, and size that will be completely destroyed on the cluster site, which represents about a third of the site?
I'm pretty certain there was an extensive tree survey and tree plan that was submitted as part of the application.
Are you saying that tree plan surveyed the trees to be destroyed on the cluster site?
My testimony is that you're looking at the property from a planning perspective, looking at this property as a whole, understanding that it will be developed as a private property. It's either going to be developed under conventional zoning or under a cluster, and the question is, does the clustering of the residential units on the property result in some unreasonable adverse impact? And the fact that the mature tree stands on the property are going to be intentionally preserved, yes, there will be some tree clearance as part of the proposed cluster development. There will be some disturbance, but it's much, much less than what would happen under conventional development, and it certainly does not rise to the level of being unreasonable, in my opinion.
And my question was very simply, if you've done no survey of the tree species to be lost on the cluster, you don't know how many will be lost, the numbers, the age, et cetera, how can you say there'll be no unreasonably adverse impact to the environment?
We even have a forester on the team who's provided an extensive presentation and analysis with photographs, provide very detailed testimony regarding existing tree stands on the property, and his findings are very clear that this cluster subdivision will not result in an unreasonable adverse impact to existing trees on the property.
My question is very simple. How do you support such a conclusion when you have done no survey of the tree species that will be lost on the cluster site?
Well, that sounds like it may be a more appropriate question for the forester who made those findings. I'm relying upon his analysis, which I find credible and persuasive.
So you can't answer that question. You suggest I speak to the forester.
Well, I'm not a forester, and I don't do tree surveys.
When you testified that the as-of-right plan requires no waivers or variances, what did you mean by waivers? What types of things did you have in mind?
Well, typically in municipalities, there's zoning requirements. There's also site plan and subdivision standards, which are oftentimes granted, or relief from those particular provisions of the ordinance are granted as waivers as opposed to variances.
Right. Were there any particular things that you had in mind when you said waivers and variances would not be needed in terms of waivers?
No.
Okay, thank you. To your knowledge, has your client undertaken any historical or archaeological survey on the site?
Well, we've had testimony regarding existing historic and archaeological resources on the property, and none have been identified.
I just asked, has your client conducted any survey?
I'm not aware of, well, they've hired an environmental expert to survey the property for those resources, yes.
I'm just about done. If I have one more moment. Are you familiar with the subject of general permits issued by DEP?
No, that's outside my area of expertise.
Okay. So if I would ask you questions, that's not a field you could answer.
Correct.
Could you return to the as-of-right plan, please? Now, you see there is a roadway in the as-of-right plan just to the right of that intersection of Herrontown Road, and that goes into the site itself.
Yes.
And that ultimately leads to 2 cul-de-sacs on the as-of-right plan. Is that correct?
Yes.
And that would be the road that is proposed if this theoretical plan were to be built, correct?
Yes.
Okay. Now, you heard testimony, I believe you were here, in which the discussion took place that general permits to build roads or bridges are not granted by DEP in vernal habitat. Do you recall that testimony?
No.
Were you present for that?
Yes.
Okay. If, in fact, general permits to build roadway in vernal habitat or bridges in vernal habitat are not granted by DEP, and if, in fact, that road must cross vernal habitat, is it still your testimony that this project can be built as of right?
Well, first of all, I've testified that general permitting is outside my area of expertise, but I will say that obviously any plan that is approved by this board would be subject to all required DEP permitting. I think both plans contemplate some crossing of existing wetland areas on the site.
Well, as a planner, if vernal habitat existed where the road would go, you would need to know that in order to recommend whether a plan could go forward to a client. Isn't that correct?
No, the plan has been, both this and the proposed cluster plan have been designed in accordance with the letter of interpretation from DEP.
I'm not
and any
asking-
permitting that's required from DEP would be presumably a condition of any approval from this planning board.
Well, if a permit to build the road and bridge was not available because that road crossed vernal habitat, would you agree this could not be built as of right?
No, because that's in the context of DEP, that's not pertinent to a site plan application where you're evaluating compliance with the land development ordinance.
If, in fact, that road can't be built because it crosses vernal habitat and permits are not available for that construction, would you still say this as-of-right plan will be built by your client?
That's entirely speculative and hypothetical, and I can't speak for my client's decision-making in that situation.
Well, could you sit here as a planner and say that will be built if, in fact, it is not legally permissible to build the roadway?
My understanding from the professionals on the team is that that is legally permissible. It may need certain permits from DEP, which, again, I'm not intimately familiar with, but any approval by this board would be conditioned on obtaining those necessary permits.
Accept the proposition, for the sake of this question, that that road cannot be built because it crosses vernal habitat and DEP permits are not available as of right for that project. In such case, would you still say to this board that project will be built?
That's entirely speculative, hypothetical. I can't evaluate, what impact that would have on the proposed development. There may be alternatives, gaining access to the site. I don't know. I haven't evaluated those.
Okay, thank you. Hang on. Thank you, Mr. Hughes. We're done.
All right. Let's go back to where we were before. I'd like to open the meeting to the public and see if they have any questions for Mr. Hughes at this point. Anyone out there? You.
Well, assuming the public has nothing at this point, we have no further cross-examination at this point.
Okay, thank you. Let me close the public portion. Did you include your other experts in the chance for the public to ask questions?
Yeah, I think you opened to the public before, but they're available except for a traffic engineer who's out of the country.
Okay. And no one seems to have come forward. It's someone reluctantly hanging back. Apparently not. So, did you want to move on to the next part?
Well, I think at this point it would be up to Mr. Afrin. We presented our witnesses. He crossed. We've reserved the right for rebuttal after Mr. Afrin completes his presentation.
Okay. So.
We're prepared to begin our witnesses at this point.
Okay.
I think we'll only have time for one. Mr. Farr will take most of the time till 10 o'clock.
Fine. Why don't you proceed with that then?
He'll need to set up. I think he has a slideshow, and we'll probably need some room over there, if you don't mind.
Okay. While he's setting up, why don't we have a 5-minute break, everybody? Could we come back into order and move along for what's left of this evening's meetings?
If you could, you have not testified previously. This will be your first time. Yeah. Right. If you could raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth? So sworn or affirm. Please state your full name and spell your last name.
Yeah, it's hard to hear you.
Okay, is that better?
It's better.
My name is Ron Farr, and I'm a certified forester and a technical service provider for NRCS. What's that? A technical service provider for NRCS. It's the Natural Resource Conservation Service.
Jerry, I'll just ask him some questions to qualify him briefly. Thank you. Mr. Farr, could you state your educational background?
Yes, I have a bachelor's degree in forestry from the University of Maine and a master's degree in environmental science from Montclair State University.
And when did you graduate from, when did you get those degrees? Approximately.
The bachelor's degree, 1988, and the master's degree, roughly 1993.
And in what occupations have you been engaged since you earned your degrees?
I've worked on the dirty end of the environment, doing hazmat and emergency response stuff, and then I came back to the green side, where I worked for the State Forest Service for 2 years, and then I worked for North Jersey District Water Supply Commission for 18 years. And then I started a consulting business for myself.
In what capacity did you work for the Water Commission?
Started off as a forester and a planner, and then ended up working on project management, and ended up working for the chief engineer at that point.
And whom do you presently work for?
I work for myself at this point.
And in what field are you engaged at present?
Forest management.
I think that's sufficient, at least at this point, to qualify him as a witness. We proffer him as an
that.
expert in forestry
All right, we accept that.
and forest management. Thank you. Mr. Farr is going to give his presentation. At this point, I'll let him do that. I may have some questions, but I'll just let him begin.
Why don't we mark a hard copy of this slide presentation, as I think we're up to 02. I think 01 may be your only exhibit, Bruce?
I honestly don't recall. I think we only have one at this point,
Yeah.
but I'm not certain.
Let's mark this as 02.
Let me just have a moment to see if this is the complete document at this point.
Yeah. Yes.
For the record, we'll present this copy, which has a date on the top, 1/23/20. It has 6 slides to a page. They're a little small. We will supply a full-size one. I didn't realize he had it on 6 units per page. Mr. Farr, please proceed.
Okay, I'm going to cover a lot of the basics considering the Landwind property, and then further experts will go more in depth on some of the subjects that I'm going to touch on today, just laying the groundwork. Starting on a wide scale, the forest of New Jersey, there's about 2.1 million acres of forest in New Jersey. It's about 41% of the land area. And in Mercer, Somerset, and Middlesex County, the average forest patch is 25 acres. So that means if you and your neighbors had a subdivision with 3-acre housing and a house on the front and woods in the back, that would be a forest patch. It doesn't have to be on the same ownership.
Maybe we should note the page numbers of the slides. That was page 2. Mr. Farr, would you just note the page numbers as you go forward?
Okay.
Thank you.
So page 3 is just a description of the ecological importance of the area. On page 4, the Princeton Ridge East Conservation Area Stewardship Plan was completed in 2014. It was done by Mike Van Cleef from Ecological Solutions. It was paid for, there we go. It was paid for by the Princeton Ridge East Conservation Area Partnership, and that includes Mercer County, Princeton Township, DNR Greenway, Friends of Princeton Open Space, New Jersey Conservation Foundation, and Stony Brook Millstone Watershed Association. Some important facts about this stewardship area. The conservation area in its entirety is about 1,700 acres, forested, residential, and all kinds of things, but we'll get to a map in a few seconds. The partnership at the time of the report owned 590 acres within that conservation area, and since then they've added 43 acres since the time of the report in 2014. From the Natural Heritage Database search that they did during the conservation plan, they had 5 state endangered species, 5 state threatened species, 4 species of concern, 3 wildlife action plan priority animal species, and the largest patch was 224 contiguous acres within this 1,700 acre parcel. So here's the 1930 aerials of the conservation area, which is outlined in red. And if you look around, Princeton was a pretty rural place at that point. You don't see many houses on the aerial photograph, extremely few houses. A large majority of it was agriculture at that time, with the north central and northwestern portion being the forested areas at that time.
Right, and you're on page 6, correct?
Oh, yes, on page 6, I'm sorry. The black parcels at this point were what was preserved in 2014, and I didn't get a GIS map of the newly preserved parcels, so I'm not sure where they fit into this puzzle. And the landwind tract is in the top left corner there, as you guys well know. So this is the same map based on 2012 aerial photography, and you get page 7, sorry. And you can see that development has basically surrounded the site and has begun to creep into the southern and western portions of the conservation area. But there still is some decent forest connectivity between these areas, including the landwind tract. The landwind tract is would be the third largest parcel within the conservation area if it was to go that route, behind Herringtown Woods and the Princeton Sewage Authority, I believe, on the top right. And it would serve as a good cornerstone for the and good connectivity for these areas for wildlife and critters to move around. So why is landwind property in the Princeton Ridge East area important? Portions of the property, and I'll get into this further, but these are just the highlights. This is slide 9. Portions of the property and conservation area were forested during the 1870s during the Vermeil studies, which I'll discuss in a later slide. And at that point, forest cover in the United States was probably at its lowest due to subsistence agriculture, the use of charcoal for energy, and firewood for heating, and wood for construction and railroad construction as well. These areas are important, especially for botanists. They harbor vestiges of what was once on the landscape within the New Jersey forests, because it hasn't been developed, the soil hasn't been turned, and some of these areas may not have been cut. If they show up on the Vermeil studies, they show up in the 1930s as forest, and they're currently forest, they may not have been cut, cleared at any point in history. These are also areas where you could find rare and native species, particularly plants. But our ecologist is going to, I'll touch on him a little bit, but he's going to talk about that a lot more. And they also serve for propagation sources for future restoration. So if there was an endangered species within this area, this would be a spot where they could come collect seeds for that plant if they wanted to propagate it and expand the range of that species. So these are the Vermeule maps. C.C. Vermeule worked for the USGS, and he was a topographic engineer. So his job was to survey and create a topographic map for the entire state of New Jersey. And he worked on this from 1870 to 1877.
Just for the record, USGS is U.S. Geological Survey?
U.S. Geological Survey, yes,
Thank
sir.
you.
And this is slide 10. So in that 17 years, when he was doing the topographic survey for the entire state, he also mapped the areas that were forested at that point. And in these maps, the forests are indicated by the dotted lines. So these areas were forest while the rest of these areas were cleared. The Princeton Princeton Conservation Site is basically this area here. And then this is where the landwind tract would sit within that site. And you can see a small portion of that property was forested in 1870 based on Vermeule studies.
Mr. Farr, does the green square appear in the physical exhibit, the hard
Yes.
copy?
Yes.
Thank you, and this is page 10.
So this is just a graphic representation of the forested area from 1870. This is slide 11. And the purple dots on this map depicted the vernal pools confirmed by DEP. So there's 3 of them on this property and 1 across the street in Herrontown Woods.
I want to ask you a couple of questions if I can. The yellow, is that the landwind tract?
Yes, the yellow is the landwind tract.
Now, what is the green shaded area on the general left side of that square?
The green shaded area was the area that was forested in 1870.
And where did that mapping of the shaded area come from?
That came from the Vermeule maps. And then I geo-referenced it using the elevations on the map.
So this green shaded area came from the USGS maps from 1870?
Yes.
Thank you.
And then this is this is slide 12. The area in green depicts the area that was forested by 1930, which is nearly half of the tract, maybe a little bit more. These areas that are forested in 1930 are important botanically, mainly because the materials that were cut at that point were probably cut utilizing horses, so there was minimal soil disturbance. And the areas had a good chance to regenerate because the deer populations were probably at the lowest at that point in 1930. But Blaine will talk more about the implications for wildlife in these 1930s and 1870 forests. But the biggest thing is that the soils haven't been turned over and heavily disturbed at that point. This is just a list of in a brief conversation with a botanist of the rare plants that are found in the Princeton Ridge and Sourland region. That was slide 13. Slide 14 discusses the rare plants that are found within the conservation area, that 1,700-acre site that the stewardship plan was done for. The plants that have the asterisks were confirmed in 2014 during the study. So there was definitely wild comfrey within that conservation zone. Botanists are a little touchy about where the location of these plants are because collectors tend to pick them up and bring them to their homes. So even if you called DEP and asked them for a reference, they would just give you a large area where the plant may be. They're not going to give you a precise location. Virginia pennywort was also found within that conservation area. And both those plants are S2 plants, so that means there's only 60 to 20 occurrences within the entire state of New Jersey for those plants. And then wood lily was also found during that 2014 study, and that's an S3, so there's 21 to 50 occurrences within the state of New Jersey. Robin's pondweed, all the plants that are listed were found during a botanical study in 1971 that was completed for the area. And again, the exact locations aren't there, it's just within that stewardship area. On to slide 15, with more discussion of rare plants. Bristly greenbrier was a plant that was found there in 1971. And I've had discussions with a large forest landowner in that region that believes she has that on her property, but I haven't personally seen it yet. Meadow parsnip was another plant that was found in that location. Again, it's an S3, so there's 20 to 50 occurrences within the state. Slide 16. These are the S1 species that were found in that conservation area in 1971, but they were not seen during the 2014 survey of the sites. And again, it wasn't a full botanical study, it was more of a stewardship study to look at invasive plants and how to restore ecology within that region. Black snake root is an S1. The S1s have 5 or less occurrences within the state of New Jersey. So they would be critically endangered within that region. Mountain crowfoot was another species that was found during the 1971 study. And death camas was the third S1 species that was found at that time. And again, these were not seen in 2014, but it doesn't mean they're not there because it wasn't a full study of the region. Slide 17 is just a title slide for forest succession. The first thing we're going to do is we're going to look at succession graphically from above, and then we'll look at the aerial photos from the area, and then the last one we'll look at forest succession on a horizontal. So again, through the available aerial photographs and available data, this is the forest cover on the Landwind tract. So this is 1870 on slide 18. This is the forest cover on slide 19 of the 1930 aerial photographs. 1995, this was the areas in green were the areas that were forested at that time. In 2007, nearly the entire property was forested with the exception of the house site and a small, looks like from the aerial photographs, looks like some sort of lawn or something to the right. And now we'll go through succession through aerial photographs. This is slide 22. It shows the 1930 aerials with the forest located along the streams, basically, and along the steep slopes.
Could you go back to 22, please?
Yes.
Just for the board's, your record's reference, there are 4 violet circles. Could you just explain what those are?
Yes, those are the vernal pools that are confirmed by DEP, and those appear in all the slides through the forest succession over time.
Thank you.
This is the aerial photograph from 1995, and you can see there was a large open agricultural area on the site at that point, and the large Christmas tree farm to the north on the northwest corner. And you can see development has certainly creeped in on the area at that point, and the next slide it'll get much more intense. This is the aerial photograph from 2002 when the condos or townhouses or whatever they are in Montgomery were built, further fracturing the forest in that area.
Can you go back to slide 24? What evaluation do you have of forest cover on the former agricultural site?
Yes, the former agricultural site, if you go between 1995 when it was clearly agricultural of some sort, there's no trees or shrubby vegetation. when you get to 2002 and you look at this area, there's clearly some sort of brushy, shrubby growth moving into the area. And as we move forward, keep an eye on the trails that are going through this stand, because they'll slowly disappear. And here's the home site, and this area is still open in 2027. Why is that? Why is this? I didn't realize my arrow wasn't showing up on the. Are you guys seeing it, or is it just not? No. All right. So if you look at that shrubby area, there's a bunch of trails through there. It looks kind of somewhat like veins or something, and those will slowly disappear. The home site is to the left of that. The shrubby area and the open area that is a lawn basically stays that way throughout. So in 2007, the development is fully developed to the north. There's further, this is slide 25. The field or agricultural area has continued to fill in over time. And you can see that the trails that were readily visible are slowly disappearing. Some of the main trails are still wide open, but the others aren't there. I have no idea why the arrow's not showing up on the screen. And then 2012, you can see that that agricultural area continues to develop and gets more intensely vegetated. And at this point, you can't see the trails at all through that area. And the house site and that open lawn area are still open. And this is 2015 aerial photograph. I have no idea why the photograph looks a little weird like that. But you'll notice the agricultural field is pretty intensely vegetated. And you'll notice that the large church cut off that section of the southern access to that forested portion. What was contiguous forest was now fragmented by the giant church there on Herrontown Road on the corner. So now we'll look at forest succession on a horizontal plane. And this is primary forest succession. Secondary forest succession would occur if you were, as a forester, if you were doing a clear cut or something. So you were going from a forest cover back into forest cover. Primary succession is when you're going from an ag field or an open area or a severe fire, where you're basically starting all over again with the successional phases. So the first few years, it'll be mostly grasses and forbs that become established. And over time, the stand initiation stage will come in somewhere between year 3 and 30, depending on the site. And this is slide 28, I apologize. So during the stand initiation phase, a new cohort of species will become established. There's likely not nutrient limitations. There's going to be rapid growth of the shrub layer, and eventually trees will move into the site. The stand initiation site could be delayed by deer pressure and invasive species, both of which you guys have a major problem with in Princeton. Eventually the forest will grow, and once it gets above the shrubs and starts shading them out, it moves into the stem exclusion phase. And at that point, there'll be canopy closure. The trees will be growing extremely densely. The lack of light is going to start shading out the shrub layer below. The trees will begin to self-prune. Nutrients are at a premium, and there's going to be intense competition for nutrients, light, water on the site based on the density of the trees. And at that point, there's going to start to be winners or losers. I was told in college that a tree was the most evil thing on the planet because they spend their whole life trying to outcompete and kill their neighbor. And during the stem exclusion phase, this is when the trees will start, the winners and losers will be determined. Some of them get shaded out, some of them will be stunted and left in the understory and eventually fade and die and become weaker. And at that point, it could be 70 to 100 or 120 years at that point. And that's when the larger trees will start dying, and you'll start getting light gaps, and that's the understory reinitiation stage. And at that point, you'll have reintroduction of the shrub layer. There may be shade-tolerant trees that start to move into the site. A lot of the pioneer species will begin to reach their life expectancy. I know people don't want to believe it, but trees have a life expectancy just like we do. Some of them are short, some of them are long. Typically, the pioneer species come in, grow quickly, and die quickly. Quickly in tree terms, not our terms. And during this stage, more shade-tolerant trees become established. They'll end up being standing dead trees within the canopy, the quote-unquote losers of the competition. And eventually there'll be down woody debris. Down woody debris. It's basically when the tree falls down, there's woody debris on the forest floor. And then at this point, maybe 150 years into the whole process, you'll get into the old growth character. I'm not a big fan of the old growth word, so it's old growth character. And in this phase, you'll have large trees with larger gaps where trees begin to revegetate the area. The limits on nutrients will decline because the big trees that were hogging all the nutrients, quote unquote, they will begin to die and weaken. It could be from wind, disease, lightning, anything that could end the life expectancy of a tree. It could be reaching its age, could be aging out of its. And then this is slide 29. In time, the forest will regrow and fill the entire site. In a post-agricultural succession, the shrub layer can provide safe harbor for tree seedlings to develop without being browsed by deer. And again, deer are probably the biggest impediment to forest regeneration at this point. In time, the seeds will find their way into the old farm site and reclaim it. And again, if this was a forest in the past and clear cut, it would respond a lot quicker than in an agricultural field. And the seeds will be delivered by wind, birds, squirrels, chipmunks, other rodents carrying stuff in, and gravity. Obviously, an oak or a hickory nut is not going to fall very far from gravity, but it'll eventually creep in. If you talk to any farmer, one of their biggest challenges is keeping an agricultural field open because the trees and shrubs keep creeping out further and further, and eventually they'll close in. Every lake wants to become a wetland, and every field in this area wants to become a forest, if given enough time and space to do so. I have not personally been on the Landwind site. The day that we had scheduled for a field day, I had state inspections for private forestry clients, so I wasn't able to make it on that day. But these pictures are taken from a site in Hopewell. Again, I wish the arrow was working, but you can see this is going through the understory reinitiation stage in this forest. You can see a lot of down woody material that has fallen. And you'll see the impenetrable jungle of Japanese barberry and multiflora rose. It's one of those sites that you don't dare walk through without brush pants, for lack of leaving with any blood left in your body. This is an area that I was hired to clear for the forestry client in an attempt to get native stuff regrowing, and we were going to tree tube any native stuff that we did find on that site. Honestly, in doing the clearing, I didn't expect to find anything native under there, but once we cut the barberry, you'll see the barberry branches kind of laying all over the place, and anything you see bright yellow is barberry stems that I had cut. And in the center of that picture is a tulip poplar seedling that was growing underneath that mess. And this is slide 31. And likely the only reason that deer hadn't devoured it was probably because that the barberry wasn't there. I mean, the barberry was there. Deer like to take the path of least resistance. They're kind of like humans. They're not going to go bushwhack if they don't have to. And then a little further over on the site, again, it's going to be difficult without the pointer, but you'll see all the yellow stems that were cut. There was Japanese barberry. The top right, there's 2 white ash seedlings. And just to the left of that, in the top center, there's an oak seedling. And then this is slide 33. And again, this was all from the same property, the same site where I was clearing about 1.5 acres of invasive stuff. In this area, again, it was mostly Japanese barberry. But underneath the Japanese barberry, there is, in the center, it's maple leaf viburnum. To the right, there is an oak seedling. And all the way to the left, there is a maple seedling that's hiding in there. And again, because of the deer, this client put tree tubes up there so they'll actually get a chance to grow. This is slide 34. And regardless, in the Northeast, basically anywhere in the Northeast or almost anywhere east of the Mississippi, the ultimate land cover, if left alone long enough, would be a forest. Eventually the trees will win. It may not be the trees we want to grow there, but there will be trees there. And I have a few pictures of areas that trees are winning, even though they'll lose in the long run, but they're winning at the current time. The left is a junkyard. Obviously that site wasn't forested when they moved all those cars in there, or else they were very gifted drivers. But again, left to its own devices, it became a forest. The center is a cabin up in Maine that, 100 years ago in the 1980s, we used to spend time there. And I went back there for the 30th reunion for graduation, and that's what the cabin looked like. And it's, in another 30 years, I probably won't be alive, but I'm sure the cabin will have disappeared completely. The right is a picture from New York City of a subway that was abandoned. And granted, it's all Atlantis trees, but it will become forest at some point. And then the left, I was riding my bike through Maryland, and I came across an abandoned subdivision, and it's quickly becoming a pine forest since it hasn't been maintained, and I guess, I don't know, the developer ran out of money or something. Slide 35 is the importance of dead wood to a forest. And again, I wish the arrow was working, but over time, trees decline and die, and it's all part of the nutrient cycle. As you guys know, emerald ash borer is everywhere, probably devouring ash trees. So when you get to the point where it's declining, it becomes woodpecker habitat. Even before, as the tree declines, and once the tree is dead, it becomes even better woodpecker habitat, and tons of insects move in there. When you get to the point when there's loose bark, or if you have shagbark hickory, that could be roosting habitat for Indiana bat and northern long-eared bat, which is a headache for foresters at this point. And then further, as the tree declines, going to the right on that top level, eventually it'll fall to the ground. And again, in a forest, its habitat, if it was in your backyard, it would be a hazard if it was along a road or a highway. There's 35 species in the Northeast that use cavities for nesting, shelter. They use the area for perches. Any guesses why a raptor or a large bird of prey would prefer a dead tree over a live tree? No? It's a lot easier for them to land with their 6-foot wingspan if the tree is dead and there's not all kinds of branches. It includes visibility so they could see their prey. When I worked at Wanakee Reservoir, we had 2 bald eagle nests on the site, and they would always be perched on the dead trees, and our executive director could never understand that. But eventually he got the picture that they could see the fish and leap out of there a lot easier if the trees were dead than if there's branches everywhere. And then eventually the log falls down. If it was a deciduous tree, which is a tree that loses its leaves, not a pine tree or a spruce tree, when it first falls, if the canopy is intact, it can provide harbor for tree seedlings to keep the deer out, because again, the deer typically aren't going to force their way through to get to it. And then as the log decays further, it could be used for ground nesting birds and a site for them to hide. And then as it declines further and further, it becomes habitat for reptiles and amphibians that need the moisture in the forest. And then eventually it'll become topsoil. So slide 36 is just a review of it. We already discussed all that, the microhabitats for moss, fungi, birds, invertebrates. And it provides habitat for 34 bird nesting species and perches for birds of prey. The coarse woody debris, it's a steady, slow release of nitrogen for the forest. And again, when the nutrients are at its least, this is a good source for them. It adds soil organic carbon, provides carbon storage, and it serves as nurse logs for trees. It's also an area where herbs, shrubs, and other things can begin to grow. Slide 37. This is just an example of nurse logs that I've found on different clients' properties. Again, there's no trees on these two images, but it's definitely the beginning of plants growing on the dead wood. And if you ever walk through the woods, this isn't a great picture, but the picture on the top right shows a strange hole on the right-hand side. And if you ever see a tree and it grows in the wood, you're walking in the woods and you see a tree that looks like a upside-down hand. I know you can't see it on the thing, but it basically started growing on a log, and the log rotted away, and that's why there's that opening. And I suspect that's why that opening on the top right picture, that black birch probably started on a log, and the log has since rotted away and left that opening in the root system. Slide 38 is a continuing of the importance of snags. Snag is a dead or dying tree. I guess that's a forester term. It's important for streams and structure in streams for macroinvertebrates. Trees falling down help create pools for fish to take a break in. And I mentioned before that it was critically important for reptiles and amphibians, particularly during the dry season. If you want to find salamanders, you go flip over a dead log or a rock, and they're typically hiding in there. They can provide nesting habitat for ground nesting birds. Most of the migratory birds that are declining in New Jersey are ground or shrub nesters, and that's because the ground cover and shrubs are in decline and getting devoured by deer. And they can also protect plants from herbivory if the trees that are fallen are random enough to keep the deer out. Slide 39 is just a titled Tree Damage During Construction. Excuse me. Slide 40, some of the damage that occurs to trees during construction, they're physical injuries. It could be cutting of roots depending on what kind of infrastructure is being installed, soil compaction, root smothering by addition of topsoil on top of an existing forest or an existing tree, and exposure to the elements that they've been protected from over the years. To the left is a picture of a tree that had a trench cut close to the trunk. And then the second picture in the center there is somebody decided, a water commission that will remain nameless, decided that they needed to water their lawn, which was a terrible example for a water company to do. But in the meantime, to put a 1-inch water line in, they cut off about 40% of the roots of those trees. And obviously those trees are in decline now that they cut off 40% of the roots, and they can't understand why now that they're watering that the trees declined. And just damage to trees during construction. Even during a tree removal phase or a logging operation, there's going to be residual damage to trees. you can't 100% determine which way the tree is going to fall unless you have a bucket truck or a crane. And also when you're removing the materials, you end up using trees that end up bumping as you're dragging the stuff out. Slide 40 is just a title about tree removal and tree damage on this site in particular. This is slide 42. The applicants acknowledged removal of 682 trees from the site based on the tree location plan that was submitted as part of the application. The trees that were mapped only included the areas of the detention basin and along the roads and the infrastructure. It didn't include, from what I can see, the areas of the actual construction of the project with the housing units. Slide 43, we did an analysis of the trees that are actually within the infrastructure and within the retention basin, but we'll get into that further. And there's another 577 trees that will be damaged or removed during the construction of the infrastructure. So in this work, we included all trees that where the grade was going to be changed based on cut or fill for trees that were remaining on site, and also anything that was in any infrastructure that was in 10 feet of an existing or a leave tree. Trees within 10 feet of new infrastructure will be impacted by soil compaction, construction equipment moving soil, either taking it away or adding it, either cut or fill, and the existing tree removal. Residual damage, if it's close enough to the infrastructure and you're putting in a sidewalk or a pipeline, you're going to end up damaging a tree inadvertently. So here's the client's tree removal plan. And this
is Exhibit 44.
Yes, slide 44, apologies. And in this slide, the engineering company that will be chatting next week or at the next meeting, all they did was they added a 10-foot buffer to the existing planned roads and infrastructure, and they also highlighted the areas where it's going to be cut and fill that trees will be impacted. The other section where trees will be impacted will be in the area of the detention basin, and the area in blue is the area that will be covered by the 100-year flood. And this is slide 45. In slide 46, within that blue area, there's an additional 217 trees that will be inundated during a 100-year flood. The tree descriptions aren't, they only give genus, they don't give species. So we were trying to look at what type of species were upland trees and wetland trees. So there are 72 maple trees within that area. If it's red maple, they can handle the water. If it's sugar maple, not so much. And you can see that most of the trees on that list are facultative upland trees. So that means 67 to 99% of the trees of that species are found on an upland site. So if you're going to flood it every time it rains, it's probably not going to end well for those species on that site. And in that section, there's 217 trees.
Mr. Farr, when you said they only gave genus and not species, when you said they, you were referring to the applicant that did a tree survey?
Yes.
Thank you.
Slide 47 is the tree identification list and tree removal list. The trees that are underlined are the trees that the applicant has stated that would be removed. The trees that are highlighted in blue, it's blue on my screen, purple on that screen. The trees that are highlighted in blue are the trees that will be inundated within the stormwater basin. And the trees in yellow are the trees where the soil would be removed or it would be cut or filled, or they're within 10 feet of the existing infrastructure on the construction plan. And that's a zoomed in picture, so you could see, you could actually read the numbers, because the next slide is the whole page, and it's a little more, it's a lot smaller, and I couldn't see it with my glasses on. So.
The slide was Exhibit 47?
47,
Thanks.
yes.
Could I just ask for clarification? I think you said the yellow trees were in the proximity to the existing infrastructure, but you meant the proposed infrastructure.
Proposed infrastructure, I'm sorry. And then this is just a large, this is slide 48. This is the entire sheet of the tree removal sheet. So you could barely see the underlined trees that were removed. And then the purple on that slide, or blue on my computer, and the yellow are the trees that we expect that are going to be damaged or need to be removed during the construction. Slide 49 is a discussion about the Princeton tree ordinance. So the tree protection zone laid out in the Princeton tree ordinance says that it's the area within the drip line of a tree as determined by section 22G above, 22-2G above. And in that definition, it's too long to read, but basically it's the outer limit and the extent of the branches, or you have to presume 1.5 feet of critical root zone from the center of the tree, 1.5 feet for every inch of the tree, measured from the center of the tree. And in the case where there's multiple trees, there'll be multiple root zone protection. So for an 8-inch tree, the root zone would be 12 feet, 15-inch tree would be 22.5 feet, 20 feet will be 30 feet, 20 inches would be 30 feet for the protection zone. And then this is slide 51. The trees are, the tree ordinance is very specific about the tree, the tree protection zones and how they have to be fenced. And if you'll notice in section 1 there, it says no contractor shall disturb soil within a tree protection zone. It should prevent, it shouldn't impede the free access of water and all that stuff. And that's kind of the basis that we use for those trees within 10 feet of the infrastructure being damaged. In slide 52, it's kind of a zoomed in picture that I kind of took at random. And it'll be trees that are not scheduled to be removed and where they are on the location map. So tree 4173 is a 20-inch oak, and again, it doesn't designate a species. And that tree, if it was a 20-inch tree, it would need a 30-foot protection zone. And for that tree, it basically covers the entire roadway or the drainage down to the retention pond. The second tree is 4174, and again, it's on the fringes of the 10-foot buffer that we put on there. And again, that one has, I don't know, it's 28.5 feet or something for that buffer. And then the last tree, which we have as a removed tree because it's a quarter of it is within the 10-foot buffer. But if you include that tree's buffer, that kind of, if they really have to, during the construction of the project, create a root protection zone, I'm not sure how they're going to hop over the fences. But that's just a small portion. I didn't have time to sit there and go through the 200 trees or 300 trees that we looked at. Slide 53 is a tree removal area, mapped versus unmapped. So the applicant acknowledges that there's going to be 682 trees removed in that tree location plan they submitted. From our study, from the engineering crew, there's going to be 217 trees that are inundated under a 100-year storm. He's not here, but I think it's 6 feet of water will be in the retention basin at that point, off the top of my head. And again, for trees that, you can't take a tree that's been growing in a mesic environment or a semi-dry environment and suddenly dump 6 feet of water on top of it and expect it to survive long-term. I just had a issue with a county that I'm working with, and they called me and asked why all their chestnut oak trees are dying. And we went to visit the site, and I told them that they were killing them. They weren't real happy about it. But basically, they created a new hiking trail, and they put a new drainage swale in, and they dumped it into this chestnut oak forest. And over the 3 years since they've completed that trail, the chestnut oak doesn't like their feet wet. And those trees are in decline, and about half of them are dead where the new stream was created. So I think the same will happen on this site based on the tree species and the water inundation. And then 577 trees that we expect to be damaged or removed based on the construction of the road and construction of the berm or retention pond. So that's an additional 794 trees or 1,476 trees total that would be removed from the site. And again, from what I saw of the tree removal plan, that doesn't include the construction of the actual home sites. Slide 54 is the 1930 forest infringement. A portion of the 1930 forest is going to be removed for the construction mainly of the retention basin and a little tiny bit for the new housing units. The other thing that will occur is the construction is going to create an edge effect that doesn't exist currently, or expand the edge effect that exists currently. And that's going to allow more sunlight to reach the forest floor. It'll change the microclimate along the edges there, and it'll allow further infiltration of invasive species into that area. And opening this area could lead to wind throw, especially of pines and other trees that haven't spent the last 150 years on an edge. They've been in the center and protected by other trees around them. And then inevitably lawn debris is going to be dumped into the forest fringe. I don't care what neighborhood you live in. You hire a landscaper, he comes and blows the leaves. He doesn't blow it into his truck. He blows it into the woods behind the house. My neighborhood does the same thing. We back up to Newark watershed property, and there's more branches and leaves and crap in the Newark watershed woods than you would ever expect in any other location. And from this, you start seeing the Norway maples creeping up the hill because everybody took it off their front lawn and dumped it into the woods in the back because that's the easiest way to get rid of it. Slide 55. These are from my work at the Water Commission. The top left picture, we had an engineering study that said that the trees were encroaching on our water line. The water line was put in 1930 or so, and over that time, it was part of the Morris Canal, so it wasn't forested at all. And over time, the forest had creeped in to the point where the trees were within 10 feet of the aqueduct. So the engineering study we had done said we had to remove all the trees within the tree root zone, which was 150 feet. And you can imagine if that was Princeton, but the people in Wayne and some of the wealthier areas in that section were not too happy that we were going to remove that many trees. So we reduced it to 20 feet from the center line of the pipe. The second year after we cleared the 20 feet from the center line of the pipe, this section in Wayne, again, these trees that were in a little further were never exposed to the wind over the last 90 years. And we kind of opened it up to the wind. And there was a bunch of blowdowns, and the people were ready to hang me in effigy for removing the trees and having all the other ones blow down. And then the picture on the right is, again, it's the Water Commission property. And again, this is in Wayne. So over the years, the landscapers of the two houses on the uphill side have just been blowing the leaves and dumping the debris onto the property. And there's no reason to expect that that's not going to happen everywhere, because it does. Slide 56, this is trying to show wind throw and how, if the wind is coming from the right to the left, the trees on the right-hand side take the brunt of it. On the top center, there's a larger tree that would take the brunt of the wind coming in at that height. And then if you remove the trees to the right currently are going to be exposed to wind that they haven't been exposed to on this site in 130 years possibly. And they're not, they haven't evolved with that sturdiness. So basically, they've been standing there protected for 100 years, and that would be like taking my kid from the suburbs in, northern Passaic County and moving him into Patterson. He'd die of culture shock. So then the other tree that may fall would be the one on the top left there, where it's above the canopy, and it may have been protected by the tree that was to the right. Slide 58 just shows I tried to get it to the trees falling down, but I couldn't figure out how to do that. But this would be the wind throw that would occur, and the trees would end up, or potentially end up blowing down because they haven't been exposed to the winds, in the past. We're almost there. 3 more slides. The slide 59 is just altered hydrology. And again, the engineering crew is going to talk more about the hydrology of the site, but I just wanted to get the basics out there. Slide 60, altering the hydrology is going to affect the vegetation growing on the site, and it's also going to have an impact on the vernal pools that are on the site. From the study that's going to be talked about in more depth by the engineering crew, 22% of the area, the water's being diverted from the wetland and vernal habitat on the southern end of the property into the retention pond. And 24% of the watershed area will be diverted from the older forest and into the retention pond. So again, that's going to impact the trees that have been growing there for 100 years based on the hydrology that they're used to. And then the 100-year rain events are going to inundate a bunch of the trees within the basin and alter their ecology and impact their life cycles. It's going to be tough for trees to regenerate if they're, especially the facultative upland species, if the ground is going to be wet from the retention pond. Or, not retention pond, infiltration basin. Slide 61 is the reasons why the land-wind property is important. It's a 90-plus acre parcel in an area where the average patch site is 25 acres. It presents a cornerstone for that preservation stewardship plan that was done in 2014. Portions of the property were forested in the 1870s during the Vernal studies, and nearly half of it was forested in 1930. It provides a connection to the larger conservation area. There's 3 confirmed vernal pools by DEP that are located on the property, and the vernal habitat. And Blaine will discuss more of that at the next hearing. There's going to be more trees removed than has been reported to date, or we suspect there's going to need to be more trees removed. And then the diversion of the water that we just discussed on the effects of the habitats on both ends of the spectrum. And that was already stated. And that's it for my presentation.
Thank you very much. I think you had
asked if we could break at a certain time for some reasons. I don't really think I can do what I need to do right now. So since he has to come back across anyway, I think if I can save my follow-up for the next week, and the next
Okay. He's coming back for cross at the next meeting, so I think we'll wind up for tonight. Is that right?
I appreciate that. Thank you.
Okay. Thank you. And thank you all for coming.
Okay.
Move to adjourn?
Wait, just a sec. We have to set a new date.
Will we all get a copy of the presentation?
We will
Like
make
email-
a full
email,
size.
I don't want it on paper, but I'd
It's
like to have
actually
it.
Oh,
too large.
PDF?
It's too large to email. I just tried
Oh.
to send it to the attorneys,
Okay.
and it's way too large.
We'll
So I
try
haven't-
to do a zip file and make it work. So.
If you save it as a PDF, it'll go.
It will reduce?
Yeah.
Okay.
Yeah, PowerPoint, forget it.
Okay.
We'll make sure to get a version that
Right.
moves.
Did you want to say something about
Dropbox or
the
Zip or
next meeting?
What's that?
Do we have a date yet?
We can go to February 6th. That would be at the end of that hearing. We have 2 other matters that are already scheduled. The meeting after that is February 20th, which is still relatively open. The open meeting with nothing on is March 5.
So, did you ever,
We obviously have quite a few experts to go, so it's going to be at least a full night total, going from, say, to 11. So Mr. Farr could continue, and I could follow up with him on questions. But if the other matters are there, we probably would only do Mr. Farr that next night, I guess. So I
don't think the 6th makes any sense. I may, or I'm flying actually back from Hawaii, arriving the morning of the 20th, so I could probably make the meeting, but I'm not quite certain of that.
So then
some-
March 5th.
Yeah.
You'll be on Hawaii time, so you can stay up till 4 in the morning.
Okay.
March 6th?
March 5th.
5th.
But I do need an extension through March 6th for the applicant, from the applicant.
No, yeah.
What was
Without
that?
objection.
Okay,
Thank you.
We can say, we can say.
I'm just
So just for the public's information, there will not be any further noticing of this March 5th meeting.
Thank you.
I'm just checking to see which experts I know here will be here March 5. I don't know about Mr. Smith. I can't reach him tonight. So we may have some that can't make it, but we'll do our best. You can be here March 5?
Okay, thank you.
Now,
Madam Chair, if I could, just for purposes of scheduling, with respect to the presentation, I would prefer that we follow the same methodology that was utilized for the direct. You're going to present your witnesses, and then we'll cross when they complete. So we're consistent that way. Right, thank you. Appreciate it.
move to adjourn.
Yes, move to adjourn.
Aye.
Everybody?
Second.
Okay.
Aye.